Okay, I'd like to welcome everyone to the 8th annual Live from L event, this year on cyber issues in international law. My name is Professor Sean Murphy. I'm the Manatt Professor of International Law here at George Washington University, and it's a great pleasure to be moderating this event, which is presented by the ABA section of International Law, with co-sponsors of the American Society of International Law and the George Washington University Law School. This particular topic, cyber issues in international law, certainly brings to mind a number of different questions. What do we mean by a cyber attack? How might states respond to a cyber attack when it occurs? Does international law regulate cyber espionage? Does international law regulate cybercrime or criminal activities occurring across the internet? Does human rights law help us in adequately protecting individuals from things like digital surveillance or the sharing of private information? My hope is that we talk about some of those questions and no doubt many others today in the course of the event. To address those questions, we have a stellar panel here from the Office of the Legal Advisor at the U.S. Department of State. Unfortunately, the new legal advisor, Jennifer Newstead, could not be with us today, but I am absolutely delighted that her deputy, Kathleen Hook, is able to be with us. Ms. Hook spent her career as a lawyer in the Office of the Legal Advisor. She started in L back in 1995 and has served as an attorney advisor and assistant legal advisor in many sections, including those that deal with law enforcement and intelligence, Western Hemispheric affairs, and human rights and refugees. She is currently one of 4 deputy legal advisors, and in that capacity, not just oversees several of the sections of the Office of the Legal Advisor, but she provides advice to senior officials in the U.S. Department of State and throughout the U.S. government on matters relating to international law and foreign affairs. Ms. Hook will start us off with a few remarks and then turn to her co-panelists. We will then have time at the end for questions from you. And when I say you, I mean not just you physically here in the room, but you who are watching on the internet, because we have provided you with a link to send in your questions. So do that. I'll be keeping a queue of them, and when we get to the time for question and answers, we'll try to get to as many of them as we possibly can.
Thank you very much, Sean. I'd like to start myself by thanking the sponsors of the event, the ABA section of International Law, the George Washington University Law School, and the American Society of International Law. Welcome. Whether you're with us here in person or watching online, we're glad you're joining us today for the 8th annual Live from L discussion on cyber and international law. Cyber issues are certainly on everyone's mind in recent years, and unsurprisingly so. Computers, computer networks, and other information and communications technologies, ICTs, permeate all aspects of our lives. Governments, businesses, and individuals depend on the security and reliability of these systems. So it won't surprise you that cyber issues can't easily be fit into traditional legal practice areas. In the private sector, many law firms are developing specialized cyber practices. We don't have a separate cyber office in L, but we do have a cross-cutting approach, tackling cyber questions on an issue-by-issue basis through our existing functional and regional offices. Let me give you some examples of the cyber issues L helps policymakers in the U.S. government address. This is a bit of an oversimplification, but the primary cyber-related issues we work on generally fall into 3 categories. One category is international and national security issues. These include issues relating to use of cyberspace capabilities by states, where the primary purpose is to achieve objectives in or through cyberspace. These are sometimes called cyber effects operations. This category also includes issues relating to how to deter and respond to malicious cyber activities by states. A second category relates to problems of international coordination. This includes the setting of technical standards, for example, for the transnational communication of data and for managing the effects of cyber policies and laws on data privacy, data localization, and cross-border business operations. It also includes cross-border cooperation and harmonization of laws relating to combating transnational cybercrime. A third category of issues we address relates to the type of internet we, the United States, and our like-minded partners want to see. This includes efforts to promote an open, interoperable, secure, and reliable internet, and efforts to maintain a multi-stakeholder approach to internet governance. We also work to promote internet freedom and help ensure that states respect and protect individuals' exercise of their human rights, like freedom of expression online. International law plays an important role in a variety of ways in helping states address these issues. First, international law is a cornerstone of the U.S. strategy on international cyber stability. It provides rules of the road for states in determining what cyber activities are permissible and the lawful options they have to respond to malicious cyber activity. In this way, international law increases the predictability of state behavior in cyberspace and decreases the risks of misperception and escalation. Second, international law facilitates resolution of problems. This can happen through international standards setting by bodies like the International Telecommunications Union. It can also happen through transnational cooperation under established international law frameworks, like the one established under the Convention on Cybercrime of the Council of Europe, also known as the Budapest Convention. Third, international law provides opportunities to address the complex challenges to business operations in cyberspace, arising from evolving and diverging legal requirements across countries. We've already seen challenges emerging from businesses conducting transnational activities in cyberspace related to data privacy and data localization, and there are many others. Finally, international law places important limits on states' regulation of cyber infrastructure and activities, especially with regard to freedom of expression and other human rights. A common thread in what you'll hear from the ELD attorneys here today is that international law plays a very important stabilizing and organizing role in how cyber issues are addressed by the international community. But before we move on to the specifics, I want to talk briefly about the importance of legal transparency and legal diplomacy when it comes to views on international laws as they apply to cyberspace. The United States has been the global leader in publicly stating its views on how existing international law applies to state cyber activities. This began with a 2012 speech by former legal advisor Harold Koh at a legal conference at U.S. Cyber Command, and it continued with now public U.S. submissions to the United Nations group of governmental experts on cyber issues, and then another speech by the former legal advisor Brian Egan at Berkeley Law in November 2016. This legal transparency and diplomacy is important for several reasons. One is that, faced with a relative vacuum of public state practice and opinio juris concerning cyber activities, others, particularly non-government efforts like the Talon Manual Project, have sought to fill the void with their views on how international law applies to cyberspace. These interpretations of international law proposed by non-governmental groups may not reflect the practice or legal views of many or most states. U.S. legal transparency efforts have been driven in part by a belief that they help clarify and in some cases even shape the law in this area. And transparency can have a stabilizing effect. States' relative silence on these legal issues could lead to unpredictability in the cyber realm, where states may be left guessing about each other's views on the applicable legal framework. And in the context of a specific cyber incident, this uncertainty could give rise to misperceptions and miscalculations by states, potentially leading to escalation and, in the worst case, conflict. Legal transparency helps set expectations of state behavior and contributes to greater predictability and stability. So we have a team of attorneys here today whose work touches in some part on cyber issues. Each will briefly address some of the key cyber issues that arise in their portfolios. You'll see they come from 4 very different L offices: political military affairs, economic and business affairs, law enforcement and intelligence, and human rights and refugees. This reflects the enormous variety and breadth of the work that we do in the Office of the Legal Advisor on cyber issues. I'll now turn the floor over to Jonathan Davis, an attorney advisor for political military affairs, who will talk briefly about the role international law plays as a general matter in U.S. cyber policy, and also about the current state of international discussions on how existing international law applies to state cyber activities.
Thank you, Kathleen. So I'd like to start, as Kathleen said, with a brief overview of the role of international law in U.S. cyber policy. A key question that states and others have been asking is how can we prevent cyberspace from becoming a source of instability that can lead to interstate conflict? And a conclusion that the United States and others have reached is that international law plays a central and fundamental stabilizing role for this purpose. You can think of international law in this context as the underlying architecture of the framework of cyber stability. It's the set of binding rules that states must follow in their use of information and communications technologies, ICTs, that helps establish settled expectations of state behavior in cyberspace. So international law has been a key pillar in states' international cyber strategies, including that of the United States. For example, in the May 2011 U.S. International Strategy for Cyberspace, which is still the operative strategy, it refers to a need to work with like-minded states to establish, quote, an environment of expectations or norms of behavior that ground foreign and defense policies and guide international partnerships. And in particular, the strategy noted the need to work to build a consensus among states on what constitutes acceptable state behavior in cyberspace. The strategy went on to talk about the role of norms, saying, quote, in other spheres of international relations, shared understandings about acceptable behavior have enhanced stability and provided a basis for international action when corrective measures are required. Adherence to such norms brings predictability to state conduct, helping prevent misunderstandings that could lead to conflict. Critically, the 2011 strategy also made clear that the development of norms for state conduct in cyberspace does not require a reinvention of customary international law, nor does it render existing international norms obsolete. It said explicitly that longstanding international norms guiding state behavior in times of peace and conflict also apply in cyberspace. And this is the cornerstone of the U.S.'s and other states' approach to cyber stability, that existing international law applies to state conduct in cyberspace. This includes the international law that governs cyber operations in the context of armed conflict, states' regulation of the use of the internet, questions of state responsibility, etc. At the same time, particular attributes of network technology require additional work to clarify precisely how this existing international law applies and what additional understandings might be necessary to supplement it. Importantly, the U.S. view is not that existing international law alone is sufficient to guarantee stability and security in cyberspace. It's not the be-all, end-all in achieving those goals. Rather, U.S. policy on international cyber stability has two additional pillars. The second pillar in addition to international law are the identification of certain non-binding norms of responsible state behavior in cyberspace in peacetime that address areas of potential risk or instability. The third pillar is the implementation of cyber-related confidence-building measures, or CBMs. Let me say a few words about norms here. This is a word that we lawyers generally dislike because of its vagueness. Norms can mean either legally binding norms, meaning international law, or non-binding norms that entail no more than a political commitment on the part of states to adhere to a particular standard of behavior, what some people call soft law. Significantly, in both cases, norms refers to standards of behavior, one set being legally binding, the other not, that serve the same goal, increasing the predictability of state behavior and thereby decreasing the risk of miscalculation or escalation during crises and helping thereby to ensure stability in cyberspace. The United States has promoted a handful of these non-binding peacetime norms. I won't address them in detail here, but I just wanted to note that this is an area where State Department lawyers have played a role in advising clients on cyber issues. Let me turn now then to the second topic I wanted to mention briefly, which is the current state of international discussions on how existing international law applies to states' cyber activities. Just to give you a sense of where we've been in this international discussion and where that discussion might be headed. So how did it begin? International lawyers have often confronted questions about how existing international law applies to new technologies. For example, 100 or more years ago to airplanes, more recently to nuclear weapons. And this challenge of determining how existing international law applies to states' cyber activities is a similar exercise to the ones undertaken with respect to those technologies. It involves the application of existing customary law, existing treaty law, and a certain amount of reasoning by analogy, which lawyers are particularly equipped to do. What makes cyber seem a bit different, however, is the extent to which ICTs, including the internet, have permeated all aspects of modern life. There's a sense that cyber is a new domain that may require rethinking existing international rules and legal frameworks for international cooperation. There's also the ability of states and other actors to cause effects and other states' territories through remote cyber operations in ways that were previously unimaginable. Furthermore, there's the widespread nature and accessibility of the technology and the relatively low barrier for using it, which animates in part the view that cyber is an area that's particularly ripe for international cooperation and coordination. So this sense that cyber is somewhat different has led states to attempt to address the question of how existing international law applies to cyberspace in various international forums, the most prominent of which Kathleen mentioned. It's a mouthful to say this group's name in total, but it's the UN group of governmental experts on developments in the field of information and telecommunications in the context of international security, or more simply, the GGE, as I'll call it. There have been 5 GGEs that have been established by the UN Secretary General since 2004. These groups' mandates have included the study of how existing international law applies to cyberspace. It was initially a group of experts that came from 15 countries, and by 2016, the group had grown to 25. The 5 permanent members of the Security Council are always involved. 2 of these GGEs have produced reports that reflect some consensus on international legal matters. In 2013, the 3rd GGE issued a consensus report that affirmed what now seems very obvious, that existing international law applies to state behavior in cyberspace. That was seen as a groundbreaking conclusion in 2013, at least by states. So believe it or not, at the time, it was a contested proposition in academic quarters and to some extent, but amongst a number of states. The consensus report also included a few statements on specific areas of international law, including international human rights law and the law of state responsibility, including with respect to the use of proxies. In 2015, the 4th GGE issued a consensus report that represented some limited progress on international legal issues. In particular, the United States and some like-minded countries managed to obtain admittedly oblique references to the inherent right of self-defense as recognized in the UN Charter, that it applies to cyberspace, as well as references to certain fundamental principles of the law of armed conflict and their applicability. Most significantly, though, the 2015 report is known less for its progress on international law and more for its recommendations of non-binding norms that I mentioned earlier of responsible state behavior in peacetime. This GG work has gained wider acceptance in the international community. In 2015, the UN General Assembly adopted a resolution calling on member states to be guided in their use of ICTs by that report, and that report was also endorsed by the G20. The 5th GGE, which ran from 2016 to 2017, did not manage to reach a consensus, and that was due to an impasse on international legal issues. A block of experts in that 25-member group opposed meaningful references to the applicability to cyber of international law governing the use of force, including self-defense, the law of armed conflict, and the law of state responsibility, including the applicability of the doctrine of countermeasures. In that GGE, the U.S. and like-minded countries sought to make clear to the international community that there are lawful response options available to states that face malicious cyber activities, and equally importantly, that any such response would be governed by established rules of international law. So in light of this failure of the last GGE, a number of people are asking, what does this mean for the future of the international discussion on international law and cyber? There have been some advances since the GGE's failure, especially in April 2017. The G7, a group of like-minded countries, endorsed the three-pillared framework for international cyber stability, and it also issued a statement that represents the most significant multilateral explanation of how international law applies to cyber activities, and included references to international human rights law, the jus ad bellum, including self-defense, the law of armed conflict, law of state responsibility, including countermeasures, and the law that governs the attribution of cyber acts to states under the law of state responsibility. Where the broader international conversation beyond this like-minded group of G7 states goes in the future is still the subject of a lot of discussion, so we'll have to stay tuned. I'll stop there.
Okay, thank you, Jonathan. I'd like to introduce our second speaker now, Michael Aktipis, an attorney advisor in the Office of Economic and Business Affairs. He will speak briefly about the international legal framework applicable to international telecommunications, in other words, the technical backbone of the Internet, and Internet governance. He will then briefly discuss some of the novel international legal challenges that have arisen in the context of the so-called digital economy, such as those relating to data privacy and requirements for data localization. Thank you.
Thanks, Kathleen. And I will do my best in the 10 or so minutes I have to cover a lot of material, so bear with me. But I want to take a step back quickly just to kind of frame what I mean by international telecommunications law and internet governance, because they are quite distinct, and it's important to kind of think about the difference. And bear with me as we talk a little bit about how the internet functions. I'm not going to get into a lot of depth, but some of this is important for framing the discussion. So when I talk about international telecommunications law, think about the kind of law that's necessary to facilitate the technical cooperation that you need for global interoperability of telecommunications. Not the computers necessarily talking to each other through the internet, but communications themselves. You can think, this framework goes back to at least the mid-1800s, everything from, think about telecommunication media, everything from submarine cables that were used to carry telegraph messages back in the 1800s, to radio, telephone wires, fiber optic connections, and now mobile broadband going over radio signals again today. And then there's a distinct area, at least how I think about it analytically, with internet governance, where we're talking about this kind of hybrid area of some aspects of international law and domestic law that creates a governance structure for the operation of the internet, which is a global kind of network of networks. Now, I want to take a step back and provide an imperfect analogy here, but how you can kind of think about how these two things interrelate. And maybe thinking about it in the context of human communication can be a helpful analogy. So where international telecommunications law, you could think about it as akin to providing the framework that allows humans to speak, to produce sounds. And allows your brain to transmit these sounds and receive them, independent of the content that they convey. You can think about internet governance as these other elements that allow speaking and understanding a particular language, the kind of vocabulary, grammar, and syntax to speak a certain language. This is kind of, you can think of the internet as that subset, that a language that allows members of society to speak together in this global network. So first, international telecommunications law. Like I said, it goes back to the 1800s. The International Telecommunication Union, which is today a UN specialized agency that deals with these kind of international telecommunication issues, was originally founded as the International Telegraph Union back in 1865. And as technologies have changed over time, they've also rebranded, wisely, I think, to the International Telecommunications Union. Now, under the ITU framework, there are a number of binding international legal instruments. There's a constitution and convention, there are radio regulations, international telecommunication regulations. You could have a whole semester-long course or year-long course going into them. But I think the key thing to focus on here is that they're focused on this notion of international telecommunication. So in other words, the kind of international legal obligations here relate to the technical operation of the telecommunications networks. It's not what we'll be talking about in a second about the internet itself and how those communications go on, the kind of level of speech and grammar that allow that whole internet, the society here, the analogy to the internet to talk. So it's not surprising given the number of international legal instruments here that there is a significant L role in the ITU and international telecommunications law. And in my capacity, I serve on U.S. delegations to ITU meetings, and we have, in fact, coming up later this year in Dubai, the kind of once every 4-year plenipotentiary meeting where potentially the treaty texts that underlie the international telecommunications might be revised. So now pivoting to kind of internet governance, it's a related area, as I noted, but it's kind of a hybrid form of governance here. And L's role is more limited here for that very reason, that there isn't kind of a national government role necessarily. It's much more indirect in the operation of the internet itself. So there still are very significant technical coordination issues when you think about the functioning of the internet kind of standard setting, and there's often a thin line between the technical discussions about how you have computers talk to each other and understand each other, and kind of fundamental policy discussions as well of who should own what, who should be able to control what. So as I noted, the internet you can think of as a global kind of interconnected system of networks that are connected together, that have a common communications protocol that allow them to actually understand each other. Now, the question arises, how do these networks know how to talk with each other? Who defines the language? And this happens at a few different levels, but just to kind of provide some illustrative examples of how internet governance, how diverse it plays out. If you think about the actual, fundamental, how do the computers talk to each other? The internet is, the backbone of the internet is something called TCP/IP. For those of you who are familiar with computers, you'll have heard of this, Transmission Control Protocol / Internet Protocol. Now, what does that mean? Well, it's essentially just the fundamental kind of technical language that the computers can talk to. It doesn't have anything to do about how do you find, when you type in Amazon.com, how does it find the relevant servers that host that content? That's a whole other separate issue we'll talk about briefly. But essentially, there has to be somebody who is coming up with these standards, updating them over time, and that's done in the case of the internet by a nonprofit, kind of non-hierarchical standard-setting organization that's based in Reston, Virginia, called the Internet Engineering Task Force. Now, this kind of standard setting of these non-hierarchical, nonprofit organizations happens throughout the internet. There's another thing when you come to the World Wide Web, www.whatever.com. There are kind of what you can think of as programming languages, HTML, if you know for those of you who back in the day would program HTML sites, I think those are a lot less common today with increasingly complex programming language, but essentially somebody has to decide how are we going to define the content of web pages. That's another standards organization that's not incorporated. It's actually formed by a joint agreement between several host institutions, including MIT, and they define those standards. So again, a very kind of hybrid way of finding that common language. Now, there are a lot of very complex issues and issues that have been in the public discourse the last few years regarding the issue of domain names. You may have heard of the so-called IANA transition. This was a big political issue the last few years. Just very briefly, so you understand the context for those of you who aren't immersed in these issues, it kind of comes down to when you go into a web browser and you type in google.com, how does your computer know to find the server that hosts that content? So there's kind of a directory system that keeps track of names, and those names are tied to particular addresses called IP addresses. So kind of long string of numbers, and that string of numbers is the address of the computer that has that information. This system used to essentially have oversight by the U.S. government. There was a contract with an agency within the Department of Commerce that oversaw the operation of the system that was recently transitioned to within an organization called ICANN to the function of their board of directors. So essentially within the bylaws, these are the kind of most complex and long bylaws I've seen of a nonprofit organization. It's incorporated in the United States, but it has incredibly complex provisions that allow what we call the multi-stakeholder community, representatives of governments, but the emphasis, it kind of comes away from governments and focusing on all kinds of other stakeholders who have input into how the policies are set and ensuring that issues, for example, recently there was a big issue of who owns .amazon, not .com, but you're transitioning to see different web addresses that instead of having .com or .org, they're whole other web addresses, and there are some disputes between Amazon.com thought that they had the right, they should be able to own this, and countries who believe that they had kind of a right to that kind of internet property. Just a way to kind of think about the intersection of these two realms, because they aren't completely discrete in the sense that a lot of the political debates that still go on today involve the extent to which the kind of technical communication, the law that governs that technical communication layer of the internet should intersect with internet governance, and a push for certain countries want to have a kind of more top-down national government control over internet functions, and they try to merge these worlds together. For example, in the ITU, having the ITU assume a greater role over internet governance issues. I don't have much time left, but I just want to talk about one issue in digital economy that is something that I think illustrates some of the kind of unique challenges we're facing today with regard to business operations. And that relates to the ability of companies to transfer data across borders. And in particular, there's an illustrative case in the context of European personal data privacy. So there, in Europe, in order to transfer personal data from Europe to another country, for example, in this case, to the United States, there is a requirement that the European Commission determine that the data protection framework in that country that receives that data, where is adequate, comports with the standards that apply in Europe. There was a framework that existed for many years, going back to 2000, called Safe Harbor, that allowed companies to self-certify with the Department of Commerce and essentially through that process show that they would comply with certain principles that aligned with European data privacy principles. And if a company is self-certified, then they could transfer data from Europe to the United States and have some degree of legal certainty that they wouldn't be in violation of European data protection requirements. Now, in 2013, this framework was challenged by an Austrian law student named Maximilian Schrems, who, in the context of the Snowden disclosures, alleged that the transfer of the data from Facebook's Irish subsidiary, where Facebook had a data was hosting its data, hosting its data, and then it was transferred to the United States. He alleged that this transfer violated EU data protection law because Facebook couldn't guarantee adequate protection when that data was transferred to the United States. In particular, highlighted the Snowden disclosures as a basis for his allegations. Now, this was referred from Ireland to the European Court of Justice, and the European Court of Justice found that a destination country, such as the United States, must not only provide adequate protection, but essentially equivalent protection to that which was provided in the EU. And in the case of the Schrems decision, that included having safeguards applicable to government access to transfer data, essentially access by the intelligence community, in this case, to data that would be hosted in the United States. So Safe Harbor was invalidated, and there was a scramble to replace this framework with one that would comport with Schrems and that would provide some sort of legal certainty for business operations in Europe. So the EU and the US negotiated a replacement arrangement called the Privacy Shield. And essentially, it's not a binding international agreement, but it is a political commitment from the United States in the form of letters that outline the data protection framework that exists in the United States, and in particular had letters also from the intelligence community outlining the way in which they can lawfully access this personal data. And there was a creation of a new mechanism in the State Department called the Ombudsperson mechanism. And this was intended to be an independent mechanism through which EU individuals could submit inquiries to receive confirmation through this ombudsperson mechanism that there had been no violation of those laws that were outlined in the package of letters, and if there were violations, that those had been remedied. And this is with respect to their individual personal data that may have been transferred to the United States. So a pretty extraordinary mechanism, not traditional international law, binding international law, but still a kind of a novel creation to deal with these cross-border jurisdictional issues. So now this is, of course, being challenged in European courts, and it's a thing to watch. So if you keep an eye on it. So this is just kind of one aspect of digital economy issues. We deal with many of them in L, but I thought it's an illustrative one to show the kind of diversity of things that we deal with in international law and in regard to cyber. So thank you.
Thank you. Thanks, Michael. I'd now like to introduce our third speaker, Elizabeth O'Connor, an attorney advisor in the Office of Law Enforcement and Intelligence. She will give us some brief background on the Budapest Convention on Cybercrime, which provides the principal international framework for combating cybercrime globally. She will then discuss some of the legal challenges raised by rapid technological development in the years since the Budapest Convention entered into force, and this includes issues raised by fundamental changes in the way that electronic data is created, transmitted, and stored.
Thanks, Kathleen. So I'm just going to give a very brief history of cybercrime. How did we end up with a cybercrime convention? So modern cybercrime is about 40 years old. In 1981, there was the first U.S. arrest of a hacker named Captain Zapp, who hacked into AT&T computers and changed their internal clocks so that all of the people who were calling at night to get discounts instead got charged like peak usage fees, and all of the people who were actually calling in the middle of the day when the fee should have been the highest got these great discounts. It took them almost 2 years to catch him. He was only sentenced to like a few years in jail and probation, and is now actually like a really expensive consultant for companies on how not to get hacked. But that was sort of the beginning of modern cybercrime and its effect on sort of business interests in a meaningful way in the United States. So in 1984, we get the first federal statute which specifically gives jurisdiction over online crimes, and it gives them to the Secret Service, actually, via the Comprehensive Crime Control Act. In 1986, we get the first specific federal substantive statute on kind of computer crime called the Computer Fraud Abuse Act, and it makes it a crime to break into computer systems federally for the first time. It takes a few years for other countries to follow suit. So the first sort of comparable legislation we see is the Computer Misuse Act in the UK in 1990. In the interim, we have the first very large-scale attack costing a lot of money in the United States when $70 million is stolen by hackers from the First National Bank of Chicago. It takes 5 years for the first, what we consider sort of the first large-scale international attack, which is Russian hackers get $10 million from Citibank and they transfer it to accounts all over the world. So that sort of leads people to the recognition that this is a real problem and it's a global problem and it might start happening to them. So in 1996, the Council of Europe establishes a Committee on Crime the Council of Europe's Committee on Crime Problems establishes a committee of experts to sort of deal with cybercrime on an international level. And it gives them a terms of reference to sort of think about and suggest that they draft a convention to deal with these issues. And that's the first treaty that sort of makes any kind of attempt to deal with computer crime. So negotiations for what would become the Budapest Convention on Cybercrime, they start in 1997 and they end in 2000. The L representative on the committee was actually Rich Visek, who is one of our Kathleen's co-deputy legal advisors, until recently was the acting legal advisor. So that convention is successfully negotiated. It takes a year longer than expected, but they actually successfully negotiate it. And it opens for signature in 2001. In 2004, it enters into force because enough countries have ratified. The United States ratifies in 2006, back when we used to ratify treaties at a reasonable rate. And so it's been in effect now for more than a decade in application to the United States and sort of almost 15 years in terms of its effect on other countries. So that Cybercrime Convention has three main focuses. First, it tries to harmonize domestic laws substantively on cybercrime issues. Second, it empowers domestic authorities to investigate and prosecute cyber-related crimes. And third, it facilitates international cooperation in that kind of investigation and prosecution of cyber-related offenses. So the first category of things, the substantive provisions. Its goal is to harmonize the domestic criminal substantive law elements of offenses and connected provisions in the area of cyber law. So it's kind of a mouthful, but basically it wants to require countries who are parties to the convention to make certain things illegal, certain substantive criminal cybercrime offenses, what we think of as sort of big C cybercrime nowadays. So that covers illegal access, illegal interception, data interference, system interference, misuse of devices for any of those purposes, computer-related forgery, computer-related fraud. It makes certain sort of offenses related to child pornography and copyright, so sort of traditional crimes, but they're now even bigger deals in the cyber context. It handles them specifically. And sort of the harmonization of laws and sort of making common understandings of what are criminal offenses in the cyber realm is really helpful, obviously, in combating illegal cybercrime. It does it directly by making it illegal in more countries. It does it sort of indirectly because it provides the basis for international cooperation through things like mutual legal assistance agreements and extradition, especially things that rely on dual criminality provisions. So it makes sure that every country has these things as illegal. And one of the big motivations was also to stop a race to the bottom, right? We don't want cyber criminals who can sort of operate, unlike some traditional criminals, cyber criminals can really operate from anywhere. We don't want them running to the country that has the loosest laws so that they're beyond the reach of the countries who they're actually targeting. So one thing that's interesting about these substantive provisions, this is all sort of a given now, right? Like obviously illegal access without consent to computers is illegal and hacking is illegal and all of these things. But at the time, sometimes when we negotiate international treaties, harmonization of laws is really involves some tweaking, changing laws a little bit to make them all fit together. Here, these are actually for about half of the signatories to this convention. This is the first time they had any of these laws. So we're kind of wholesaling making up cyber law in the negotiation of this treaty in a way that you don't normally see in international treaties, at least nowadays. So the second set of things that are contained in this are procedural provisions. So these provide for domestic criminal procedural law powers necessary for the investigation and prosecution of these types of offenses, but also for offenses committed by means of computers or that involve evidence in electronic form in relation to any crime. And I think there was some recognition even at the time that this was sort of a big deal, that electronic evidence beyond just traditional cybercrime was like going to become a big thing. But I don't think that anybody really foresaw that that would now be the massive focus of these sort of substantive procedures. Because in fact, the largest crime that is investigated using these procedures, and in fact that there's international cooperation in regards to, is financial computer-related crimes. And the next largest category is serious crime having to do with like murder and rape and sort of very traditional crimes, but for which electronic evidence is necessary since it's so ubiquitous in modern life. So there was this real focus on cyber-specific offenses at the time of negotiation, but now the focus is as cyber became kind of everything and not just like a specific category of life, it's actually the everything that is kind of the focus of the international cooperation elements of the agreement. So we have these procedural tools for investigating and combating cybercrime. They cover three kinds of data. Subscriber data, so who is the person, who is the user. Traffic data, so information about their communications, like the origin, the destination, the route it takes, the type of communication, the time it was sent. And then content data, so what it actually says. And the content data is then further divided into two states: stored data that sort of exists somewhere and is already there and is waiting for you, and real-time data, so data that's occurring sort of at, which you could almost think of in the telephone context as a wiretap, so like monitoring emails as they're being sent. And then it talks about the methods of preserving, finding, collecting, intercepting, and producing this sort of data. And basically what this whole section of the Cybercrime Convention does is it tweaks existing tools to the cyber context. So it deals with things like production orders and search and seizure rules, which we have in fighting all sorts of crime, but it changes them and tweaks them to deal with the unique features of cyber and cyber data. So the fact that the data is volatile, it's deletable, it's duplicatable, it's non-physical in lots of cases, and it sets up sort of the tools the government should have for investigating crimes using this type of evidence. And importantly, for sort of where we are now, it defines these tools, who these tools apply to by reference to the territory in which the person is situated, who has possession or control of the data, and or by a service provider offering services in the territory. So it's a territorial principle, but it focuses on the person or the service provider as opposed to the data. It's obviously really good to have these tools for fighting cybercrime, and it's necessary for the international cooperation that piggybacks on these provisions to have these provisions in place to begin with. This section also contains a couple of other things worth noting. It has a lot of conditions and safeguards. It explicitly applies these to each and every tool. It implies a balance of rights. It doesn't specifically talk about the conditions and safeguards that have to be in place, but much like Jonathan mentioned when he talked, it basically says the rules you have that govern individual rights in other criminal justice contexts in your system also apply in the cyber realm. So it implies, without stating, that people have the same kind of rights to privacy, et cetera, in the cyber realm that they have in real life. And the other provision is it has a jurisdictional provision, but the jurisdictional provision is, and it again is based on this territorial concept. It's a floor, not a ceiling. So it says every state has to establish jurisdiction over actors in their territory, but it explicitly says we're not stopping you from exercising jurisdiction on other bases that you might exercise jurisdiction on the basis of. And it gives no real guidance at all for conflicts. It says you should consult with each other and you should choose the most appropriate venues and jurisdictional hooks that you can. So basically nothing, which is not surprising because we have a hard time agreeing to these sort of jurisdictional principles in any context, let alone this like newly emerging cyber context. So the third kind of category is these international cooperation provisions, and these aim at setting up a fast and effective regime of international cooperation. It basically looks like a cyber mutual legal assistance treaty, and it focuses on countries obtaining evidence that can actually be used in court. It covers sort of two things: traditional mutual legal assistance. It specifies that where there is no treaty or arrangements between parties to the Budapest Convention, the specific general principles that are in the Budapest Convention will apply. But where there is a treaty or arrangement, that treaty or arrangement will still govern, and it will specifically apply to cyber activities, even if it doesn't talk about them. Then the second big category of things is cyber-specific MLAT offenses. So those apply in both scenarios, and they basically cover the same procedures as the procedural provisions in the second category. There are a few tweaks on that. There's a few more conditions and safeguards that are put into place in terms of international cooperation using those provisions. But basically, it's like the second section of procedural things says you need to have search and seizure, you need to have international production orders, you need to be able to preserve data in an expedited fashion. And then the third section says, and you need to share and cooperate internationally all the things you get using those tools, subject to certain conditions. So, and importantly, sorry for one other thing, it has a unilateral trans-border search provision, but the only thing, and there's actually an explanatory framework to the convention that is really helpful in seeing why certain terms are left vague and why certain provisions are included and others aren't included. And in that, it explains that really parties couldn't agree on unilateral trans-border access to data. So the only things that they could agree were that it was okay to unilaterally access data across borders, so basically without the involvement of the country where the data is at all, when you have the consent of the party who is lawfully authorized to disclose that information, or where the information is publicly available. And it says, we're not making any kinds of judgments about any other scenarios, but in those two scenarios, it's okay. So where are we now on Budapest? We now have 56 parties, including a host of non-Council of Europe parties. In addition to the US, there's Sri Lanka, Mauritius, Tonga, the Dominican Republic, Japan, Canada, and there's 14 other countries that are in the process of acceding. It's the closest thing we have to a global standard. There are certainly massive critics of it. There are countries that call for new UN instruments to replace this instrument, They're largely the kinds of countries with whom we couldn't reach an agreement at the GGE on the rules of cyber writ large. They have a very different view of cyberspace for any number of reasons. But 130 countries around the world have used the Budapest Convention standards to establish their own domestic laws. So even when they're not parties, it has been a huge influence on how cybercrime statutes are structured worldwide. We're in relatively good shape. The convention, rather, it doesn't use technology-specific terminology, so it's been able to adapt pretty well to new forms of technology. And it allows a lot of reservations and opt-outs, which is good because it's flexible, so it can work for different national systems. But on the flip side, it means that there isn't really a full meeting of the mind on a lot of these issues. And of course, we've had this explosion in the cyber world, so that has made every unanswered question that was left even more important. And it's created a huge backlog of cases. A big study done by the Budapest Convention Committee found that the average request for mutual legal assistance under the convention took between 6 months and 24 months. Obviously, it's very hard to fight cybercrime if it takes you 2 years to get an answer, where you might just be asking for the subscriber information of the person. So you want to know who might have committed the attack, and 2 years later you find out, oh, it was this guy 2 years ago who, we don't have any other information about him, but 2 years ago you want to know, his name's Fred Smith. So what's next, very briefly, is that we need to figure out the answers to a lot of the questions that remain. We need to figure out what the US thinks the right answers to the questions are, and we need to figure out whether or not we can reach any kind of compromises in the international community over what the answers to any of these questions are. There's a lot of open questions and issues, specifically a lot of them raised by the phenomenon of cloud computing. In the non-technical sense, that's just data isn't being held on specific devices or enclosed networks. Instead, it's distributed over different servers, different providers, different locations, different jurisdictions. So data isn't in one obvious place, and it often is nowhere near the service provider that's offering the service, or the person who's using the service, or the victim of whatever crime was used using the service. So the US government, we don't even have an answer in our perfect world for how law enforcement should be accessing this information. We're kind of just starting to come up with one. There's a case pending before the Supreme Court now, the Microsoft case, which is basically a US company, Microsoft. The data that the US government wants is located in Ireland. Microsoft is capable of producing the data. It does possess and control it. And the question is, can US law enforcement get the data? Can it force Microsoft via a US-based probable cause warrant issued by a US judge to disclose the data under the Stored Communications Act? It's gotten a lot of attention because of the international comedy and privacy and all the sort of values that are wrapped up in it, but actually the case itself is a statutory construction case about what the Stored Communications Act actually does. No one disputes that Congress could amend it to allow us to access the information if that's what Congress wanted to do, but it's raised a lot of these open questions and disagreements that are out there in terms of, you know, who has the right to access what data and who has jurisdiction over data that's out there, are wrapped up in this case. In this particular case, there's seemingly a relatively limited effect on Ireland. It's a US company, it's a US person, we think, whose data they want. The data is stored in Ireland by an automatic process designed to reduce lag in the system, so it doesn't have any particular connection to Ireland. And also the target could have voluntarily handed over the data to us, even under Budapest. And so it doesn't seem like Ireland necessarily has a protective role in this data in an obvious sense. On the flip side, you could imagine if it was an Irish citizen or Irish government information, the same tools we used would, according to the US government, still be applicable. So we could imagine circumstances in which Ireland has a very obvious role and a very obvious equity in the data, where the same argument we're making now would still apply to those circumstances. And sort of, you know, on the flip side, devil's advocate, we could have gotten this information from Ireland via a mutual legal assistance request, and we didn't go that route. So in this case, there was an international cooperation tool available, not actually the Budapest Convention, because Ireland is actually one of the very few like-minded countries that is not a party to the Budapest Convention, but we could have gotten it through an MLAT request. So no isn't a big loss here the way it might be in other contexts, but you know, what if we didn't know where the data was? That happens a lot. What if it's in multiple places? What if it's constantly moving? What if the host company intentionally sets it up so that every time you ping the location of the data, it is automatically moved to a different location? Those things are all realistic technology possibilities now and actually are how lots of cloud computing operates. So going with a system that says you have to ask for permission of the country where the data is, doesn't actually solve all the problems. So no could be a big problem here in other contexts, even if it's not a big problem this one. So in sum, Elle's role at the moment is that I'm the State Department delegate on the negotiating committee that is trying to negotiate an additional protocol to the Budapest Convention to cover all of the issues raised by cloud computing. So at the end of 2017, we started negotiations on this new protocol. It's supposed to go through the end of 2019, so there's a long time to go to see to what extent we can solve any of these issues. But we're largely looking at trying to make mutual legal assistance faster and more effective, trans-border access to data in a unilateral fashion, so sort of the Microsoft scenario and related scenarios, direct cooperation with service providers on either a mandatory basis or a voluntary basis. The US permits it voluntarily in certain circumstances. Europe does not permit their providers to voluntarily cooperate with foreign law enforcement in any circumstances. And then we're also looking at safeguards and data protections that would need to be in place, especially for this kind of direct cooperation with businesses, for some of the reasons Michael highlighted, including European court judgments that basically say this is a non-starter for European countries unless we put in some of these safeguards and conditions. So that's where we are now, and like Jonathan, sort of stay tuned for 2 or 3 years to see if we can solve all of these problems.
Thank you, Beth. Okay, so we have our fourth speaker. I'd like to introduce Haley Bolin Shellito. She's an attorney advisor in the Office of Human Rights and Refugee Law. She's going to cover internet freedom and the protection of international human rights online, including freedom of expression. And in particular, she's going to address states' efforts to counter violent extremism and hate speech online, and differing approaches to engagement with industry, from voluntary collaboration to regulation, including intermediary liability. Thank you.
Thanks, Kathleen. And also, thank you for bearing with me through my cough. I will do my best to get through this as efficiently as possible. Article 19 of the International Covenant on Civil and Political Rights, the ICCPR, states that everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other media of his choice. Article 19 of the Universal Declaration on Human Rights, the UDHR, contains nearly identical language. Both of these documents were negotiated long before the internet became a part of our daily lives. The UDHR was adopted in 1948. Negotiations on the ICCPR concluded in 1966. But they were surprisingly forward-leaning in their use of language about expression and seeking and receiving information through any media, regardless of frontiers. So while on its face, this language seems to make quite clear that online expression is protected by freedom of expression, of course, not all states have been fully supportive of that view. However, in 2012, the UN Human Rights Council adopted its first resolution on human rights and the internet, in which the Council affirmed that the same rights that people have offline must also be protected online, in particular freedom of expression, which is applicable regardless of frontiers and through any media of one's choice. This resolution marked the first time that the Human Rights Council expressly addressed internet freedom. And you'll note that while it specifically mentions freedom of expression, the language does not apply only to freedom of expression, but to all of the rights an individual has offline. The same language has since been adopted by the UN General Assembly and in a number of later Human Rights Council resolutions. However, it will come as no surprise that despite public consensus around the protection of human rights online, states take very different approaches in practice. Nowhere is this more clear than in states' approaches to countering problematic content online. As you are almost certainly aware, there is growing concern over terrorist content and hate speech online. It's a topic of intense debate in the international space and an issue in which a number of offices at NL are quite involved. From a human rights perspective, this raises two issues. The first is not strictly limited to cyberspace, but the internet has increased the urgency around it and has exacerbated pre-existing differences in views. And that question is, what content is protected by freedom of expression? In the United States, of course, we have very extremely broad protections for speech in our First Amendment. For example, incitement generally cannot be criminalized unless it constitutes incitement to imminent lawless action, or what we typically say internationally, incitement to imminent violence. That's the standard from Brandenburg, and the U.S. advocates for internationally to be the standard under Article 19. Specifically in the online space, just this past June, the U.S. Supreme Court issued a fairly sweeping opinion in Packingham about protections for speech on social media, comparing cyberspace and social media in particular to a street or a park for purposes of First Amendment analysis. However, the U.S. is an outlier in the strength of its protections for expression. Many other countries, even countries that we typically agree with about other human rights issues, have laws prohibiting speech that would be protected in the U.S., such as hate speech, defamation of religion, certain types of propaganda, extremist content, and insult, to name just a few. Differing understandings of freedom of expression are one thing when we're talking about in-person speech or newspapers that only have domestic circulation. But in a digital world, when online expression is prohibited or censored in one country, it impacts access to information globally. Likewise, when a speaker is in the United States and is posting inflammatory but protected speech online, that speech can reach a much broader audience and can even raise some diplomatic issues. In the context of countering violent extremism specifically, this is something we really have to work on with our partners to make sure that our work in this space is appropriate in light of our views on freedom of expression. And the second issue in this space is who should be responsible for addressing online content deemed illegal. In the United States, social media platforms are generally protected from liability for what individuals post. But once again, the U.S. is somewhat of an outlier. Internationally, we see trends of governments imposing liability on private companies for illegal content posted to their platforms. And separate from the question of whether the underlying content should be protected by freedom of expression, this movement towards intermediary liability raises additional human rights questions. So, for example, in Germany, you have the NetzDG law, which regulates social media platforms by extending existing prohibitions of certain speech to online platforms. So as of January 1st, social media platforms must remove reported illegal content within 24 hours in a straightforward case or within 7 days if the evaluation of the content is more difficult, and face steep fines for failing to comply. And a number of other countries are considering similar legislation. So one of the most significant concerns here is that the incentive structure leads to overbroad content removal. When a company will be fined if they don't comply, where there is any question about the lawfulness of the content, the incentive is to remove. Some have articulated concerns that this type of law privatizes a public function, and this raises additional questions. What procedural safeguards or appeal rights should be in place? Can someone appeal to a company to have the content restored, or can they appeal to the government? Can someone get an official opinion about whether the content is illegal, or do they have to rely on the company's decision? An intermediary liability for content takedown also raises some fairly complex jurisdictional questions along the lines of what others have raised. So if a social media company complies with the state's order to completely remove content or block access globally, that information is inaccessible worldwide. Of course, a company's decision to comply with an order could be influenced by any number of factors, such as the size of the fines or other penalty, including whether or not they'll be permitted to continue to operate in the country, number of users in the country, and even whether the company agrees with the underlying reason for the takedown order. This problem was previewed by earlier concerns of the European Court of Human Rights case law on the right to be forgotten, which some of you may be familiar with. But I expect that the proliferation of efforts to counter violent extremism by compulsory content removal is going to be a much more serious threat to freedom of expression going forward. And part of that is because these types of laws are being copied and abused by regimes that have less positive intent. And it kind of brings us full circle to the question of what should be protected by freedom of expression. If a well-meaning government requires Facebook to remove extremist content as a means to counter violent extremism, it is much more difficult to criticize a regime who requires Facebook to remove extremist content, but defines extremists to include political opponents. Or if you outlaw online speech that discriminates on the basis of political opinion, it's not hard to see how our government could quickly turn that into a tool to suppress political dissent. And then you quickly see how this devolves into an internet in which only the lowest common denominator of speech is allowed. If one country is effectively able to regulate online content worldwide, then the most repressive regime is deciding what is allowed on the internet. Now, intermediary liability is not the only way to regulate expression on the internet. There are also states who take a much more direct approach, centrally regulating the internet and directly censoring content. And of course, that raises very serious freedom of expression concerns on its own. But there is room, I think, for some work comparing the impacts of these different tactics. So that is the bad news. What's the good news? What are we doing to protect human rights and also address some of these issues? There are some murmurings and pushes for a treaty in this space, but not any that really have a lot of traction at the moment, as you may guess. That's not something that the United States is actively pushing, in part because we don't think that we need anything else, right? Like the human rights apply online. We've already been saying that. So when people, sometimes special rapporteurs, suggest that we need something additional, it's almost implying that what we have isn't sufficient, and that gives some wiggle room to countries who don't want to comply with human rights. Well, what we do see are a number of efforts by states, private industry, and international organizations to promote internet freedom while also taking seriously the threats that are posted online. So I'll just run through a couple of these, and I know that we are short on time, and I don't want to suggest that any of these are something that we fully endorse all the projects of them, but just to give you a scope of what's going on. So first, the Freedom Online Coalition, which the U.S. was very instrumental in setting up. It's a coalition of 30 governments that are working to advance internet freedom, and it's a place for dialogue and discussion, and they issue joint statements, a lot of which the language they push to be picked up in various resolutions. In the U.S., as part of the U.S. government, was very involved in the global counterterrorism forums, recommendations on preventing and countering violent extremism and terrorism online. There's a lot of language about the protection of human rights in that we were pleased with. In the UN space, as I mentioned, you have the Human Rights Council, which has its biannual Internet Freedom Resolution. That language has been picked up in Third Committee, notably in the Privacy in the Digital Age resolution. And then these issues concerning countering violent extremism in particular are increasingly coming up in the Security Council. Then you have less of a state-negotiated, but still a UN entity is Tech v. Terror, which is run out of UNCTAD. It has the mission of supporting the tech industry to tackle terrorist exploitation of the internet whilst respecting human rights. They are working on a number of creative ideas in this space. And then there are also efforts that are purely industry-led. So the Global Internet Forum to Counter Terrorism was founded by Facebook, Google, Microsoft, and Twitter, and they do a lot of work with smaller companies to help work on gaps in their terms of service and also to work on some technical fixes that may be helpful. So I do want to save as much time as possible for questions, but I would note that that's just one of the many issues that we work on in this space, and it's also rapidly evolving. So governments are trying to figure out different strategies and approaches, and there are a lot of open questions that don't have international consensus and sometimes don't even have consensus within the U.S. government or at the State Department. But we see novel questions every week on a range of topics. It's a lot of fun. So.
Great. Well, thank you, Haley, and thank you to all the speakers for what I felt was a fire hose of information and issues that sparks off a lot of questions. In my mind, we're already getting some coming in across the internet, and I do want to highlight, if you're watching online and would like to send in a question, the address is livefroml2018 @gmail.com. livefroml2018 @gmail.com. I'm a little worried now someone might hack into that address, so we'll just have to see how it goes. So we're going to approach this. I'm going to invite questions from the audience. If you have one, raise a hand. I'll point to you. I think we may have a microphone coming down to folks, so let's start here. But I'm also going to batch questions together, both from the audience and from online. So let's start first with Michael. You take the microphone.
Oh, thank you very much. Well, I have two questions which you may want to answer in the abstract, or even better with respect to certain specific well-known circumstances. First question, what does international law have to say about the cybernetic intrusion by one state or at the behest of one state into the electoral process of another state? Second question, what does international law have to say about the right of one state to use force in response to cybernetic activities of another state which might harm or interrupt the operation of or even destroy equipment or facilities in another state?
Take a second question from the audience, and then I've got a couple from the internet I'm going to throw out there too.
Thank you for a great presentation. One of my questions was related to his second question, which is, how do you tackle the idea of which cyber attack could constitute, let's say, an act of war, which will be trigger any other action from a country that deems that is being affected by that. And the other question was in terms of the challenges of regulating this topic, especially, in the international dimension, since not only you have the complexity or the issues about different countries with different interests, jurisdiction, and issues, but also you have the challenge of the fact that this is a very changing phenomenon. So it changes all the time. So how could you regulate, how the cyber world acts, effectively, because it will be always a challenge in terms of what new things come, what new challenges, what behavior have to be regulated. Thank you.
Okay, let me add to those two questions, two from the internet. And I would note that these are coming from places as far away as San Diego. So people are watching at least across the country, if not across the world. So one is it possible to get an idea of how international law and agreements are working or not with regard to Russian hacking into the U.S. electoral process? And then another question is, and I'm just going to paraphrase it a bit, is it lawful under international law for a state to launch malicious software in order to shut down a nuclear program of another state? Those are pretty easy questions that I'm sure the panelists are eager to address, and I think the plan is just to let you, Kathleen, figure out who you want to perhaps take them on.
Yeah, I think the obvious person here is Jonathan, at least to start.
Sure. So I mean, the questions that were bundled together, and thank you, Sean, Michael, and others for those, I think raise a number of similar issues. So I'm going to kind of address them all together. Let me start with the sort of use of force type questions that were raised. So the United States has been public about its position that in certain circumstances, a cyber act could amount to an unlawful use of force under Article 2.4 of the UN Charter, or an armed attack for purposes of triggering the inherent right of self-defense under Article 51 of the Charter and customary international law. So that's been our public position for a number of years now. The United States has also set out a number of factors that it thinks states should consider when analyzing whether or not a certain act rises to those legal thresholds. It's largely an effects-based test. This is the position of most states who have actually thought about this issue, most academics who've thought about this issue, that you look first and foremost to injury or death to individuals, damage or significant destruction of property, and that additional factors should be taken into account: the context of the event, the identity of the actor behind the cyber act, and the intent of that actor. There's not going to be a bright line rule on these types of questions. There's not a bright line rule with respect to what amounts to a use of force or an armed attack. In the kinetic domain, states aren't coming out and saying explicitly this type of scenario amounts to use of force or an armed attack. And there are very good reasons why that's the case, both with respect to kinetic acts and cyber acts. It's necessarily going to be a case-by-case, fact-specific inquiry. But that is the U.S. position, the position of a number of states, that in certain circumstances you might be able to see a cyber act that amounts to a use of force or armed attack. And it's going to look like things probably that you would see the effects of dropping a bomb or firing a missile. Those things would, if you create those effects through cyber means, states are almost certain to deem that act to be a prohibited use of force and or an armed attack. A couple questions touched on interference with electoral processes. Brian Egan, our former legal advisor, addressed this subject in a speech he gave back in, I guess, November 2016 at Berkeley Law School. And he talked a bit about the principle of non-intervention in particular. He noted that has historically been seen as a pretty narrow principle, that there aren't a lot of things that states have considered to contravene that principle of international law. But he did note that things like a state's interference with another country's ability to hold an election, or another state's manipulation of election results, would clearly contravene the principle of non-intervention. But I think stay tuned to what sort of other states think about certain acts. I mean, this is a principle of international law that is not one of the best defined ones, and it's a place where state practice and opinio juris is likely to clarify the precise contours of it. We'll stop there.
Okay, a couple more questions. I'll go on to this side of the room. I think maybe start with Sebastian in the back there, and then down.
Thank you. I'm very glad that this of this event. Thank you for this. I have a question. I think that assuming that that's the international law status today, what about? I think that there's a question of attribution applicable to these kind of things. Every time that we read about a cyber attack in the newspapers, we're not quite certain who did that. So I guess my question is it possible, how does international law address the attribution? Do we apply the general rules of international state responsibility, or are there specific rules for attribution in cases of cyber attacks? And secondly, if there's not, could there be? Is there any possibility for actually addressing that issue in legal terms? I don't know if I was clear. I can repeat that. Okay, thank you.
We'll do one more right in front of...
So my question is about, is there any change about procedure rule under the cybercrime? I mean that for this kind of illegal obtained evidence, for example, the WikiLeaks or this kind of evidence, is that possible to be admitted before the court for the individuals? It's hard to have access to this kind of information.
Okay, and I'm just going to add to those questions two more from across the internet. The first one is along the lines of, does L share the view that sovereignty is not a rule of international law, which I suppose could relate to this topic in some sense of flows across a border, perhaps is a different creature than what we normally are thinking about. And then as an additional question, and this is meant as a serious question, the questioner asks, any thoughts or guidance on ways a solo practitioner can niche into this space and make oodles of money? Which, to give it the more serious spin, might be, how is it that others outside of government might be able to work in this space? Where are the things that the private bar should be thinking about looking at? And we have students in the room. What should they maybe be educating themselves towards to help the government and others do the work in this space?
Let's start with the question on the cyber attack, and if you have any thoughts about sovereignty that you want to impart.
Yeah, well, so I think on that question, I think a good place to first look at what the U.S. has said is in Brian Egan's November 2016 speech at Berkeley Law, again, where he addressed this subject. I mean, I'll just repeat a bit of what he said, but he made the point explicitly that remote cyber operations involving computers or other network devices located in another state's territory do not constitute a per se violation of international law. In other words, there's no absolute prohibition on these types of activities, and he said this is the most clear when such activities on another state's territory have no effects or just have de minimis effects. He goes on to sort of address this issue more generally and just notes that sovereignty is also a sort of principle that informs other rules, including the principle of non-intervention. So I'd refer you to those remarks, which will go into a bit more detail. Maybe if I could address really quickly the attribution question. You asked whether states should look to the law of state responsibility to supply the standards for attributing cyber acts to states. The answer is yes. that the law of state responsibility is going to provide the same sort of rule book that it does with respect to other acts by states. A lot is made of the so-called attribution challenge with respect to cyber activities. And I don't want to minimize that. I think as a technical matter, it might be difficult, it can be difficult to determine through cyber forensics and otherwise who might be the responsible actor behind a particular cyber act. That's a technical challenge. States also encounter sort of political questions. Do we want to attribute, as a policy matter, a cyber act to another actor? That's a bucket of political challenges. But the law is fairly clear and straightforward here. There are some states that seek to muddy the waters with respect to what the law says about attribution for good reasons. They want to perhaps suggest that it is difficult to attribute, even as a legal matter, certain acts to them. They claim that you must prove your case. It's a legal requirement to offer proof before you can attribute things as a matter of international law. That's not what the law of state responsibility says, though. There's no requirement to reveal the evidence from which your attribution is made. There's no requirement to have absolute certainty. This is an area, as a general matter, where states are just required to act reasonably in their collection and evaluation of the information that would allow them to attribute cyber acts. So I expect that states will continue to look to the law of state responsibility as it is, including with respect to cyber acts.
Then with respect to the question on cybercrime, Beth, do you want to address that? And maybe you could also speak to the question that came earlier about the sort of changing technologies and how do we deal with that kind of in real time when things are constantly changing?
Sure. So first, with regards to the question about sort of the WikiLeaked information, and the Cybercrime Convention doesn't really have anything to say about domestic rules regarding whether evidence is admissible or not. So mutual legal assistance treaties are largely aimed at obtaining admissible information to use in domestic proceedings. There really isn't any kind of international doctrine or agreement that specifies what standards those should be from a domestic perspective. The U.S. is actually pretty unique in terms of how far our exclusionary rule goes in terms of keeping illegally obtained evidence out of courts. There are many countries that don't have sort of any kinds of rules like that. Even in the U.S. context, usually the illegality involved has to have some kind of government complicity. In the context of WikiLeaks, I wouldn't think that's really there for maybe arguably in a very limited sense, but in the vast majority of countries, there wouldn't have been a government complicity in the information being illegally obtained. So I would say that from my limited perspective, we do get sometimes requests from other countries, not so much under the Budapest Convention, but in general for mutual legal assistance, where they are asking for evidence that they know is out there as a result of WikiLeaks to be put in a form that they can use in their courts. That largely requires things like verifying this is actually an accurate cable, and certain like procedural things like signing things and certain certifications. It does put the U.S. in a tricky situation in those cases because those cables by and large are still classified. And in fact, we have sort of a general posture that we don't give any kind of specific answer about whether or not the cables leaked. Each and every cable in an individual sense is an accurate reflection of what the cable actually said. So it does raise some interesting issues. We also get a lot of FOIA requests where people, and sometimes in the context of like CHUI requests and other like criminal justice discovery requests as well, where people are aware that the government has information related to X topic because they read about it on WikiLeaks. So they use the WikiLeaks information to underpin their larger requests for information that we might have about the subjects they're interested in for either criminal justice or non-criminal justice reasons. But there certainly isn't a direct international law treaty that governs that kind of thing. In terms of changing technology and how we regulate, it's a huge issue in the cybercrime realm. There was a very conscious choice made when the Budapest Convention was originally negotiated to keep it as technology neutral as possible. So it uses the word computer, for example, but when you look at the definition of computer, it clearly applies to smartphones and basically any other processing technology that's out there. I think that was seen as the best we could do to try to account for the fact that everybody expects lots of rapid technological development but doesn't know exactly what it will look like. That said, There are questions that were kept open when the Budapest Convention was first negotiated because we couldn't reach agreements on them. Things as minor as whether or not hacking has to have caused harm in order to be illegal. It differs between different countries. To as major as whether or not email that hasn't been opened is a stored communication or a real-time communication. And there's totally different standards for whether or not you can, how much you need to get that information depending on how it's classified. All the way through questions that were left open only because we didn't know they existed. So nobody really foresaw this world in which 80% of data doesn't have a specific location and we don't know where it is. And even more interestingly, the methodologies we might use to figure out where it is, like the technological methods, actually would involve technical trespassing into other countries as well, right? Because tracking data actually sometimes could involve us accessing data in other countries in an effort to find out where the data is in the first place. So questions like that, they really show how much technological improvements sort of make it very difficult to negotiate when we don't know where things are going. And we're sort of, I think we did the best job we could at the time. And I think the Budapest Convention compared to other conventions is actually really good in terms of trying to be as flexible as possible to account for that. But it also is totally imperfect because that is basically impossible to do in many senses. And, when this first went into effect, lots of countries barely had an internet, and they certainly didn't have it permeate their everyday life. And now we have member countries, like from Tonga to Sri Lanka, who are now sort of totally cyber in a way that I imagine they couldn't have envisioned in 2001. So I think cyber is sort of a wave of newness that maybe is unlike anything that has been experienced since airplanes and cars. I don't know.
Great. Maybe we've got only a few more minutes, but
I think Michael was going to try to address the question very quickly about to what extent are private practitioners really working in this area?
To make oodles of money.
Just a very important caveat here. I'm not sure that government lawyers working in L are the best ones to advise you on how to make oodles of money in the private sector. But that being said, I think as evidenced by the diversity of legal issues that you heard addressed here today, and even that is a small fraction of what goes on in what you call a kind of cyber practice. There isn't a good answer here. I think there are enormous effects on the private sector across all of these issues, and that's where, when you're a practitioner in the private sector, you're looking for issues that affect business operations. So certainly there are a lot of opportunities here, and I know there's some practitioners in the audience who have made good careers in this area. I mean, I think one area that you do see a lot of kind of practice areas being built up on are the issues of data privacy that I kind of touched upon really briefly, particularly with in the EU, the General Data Protection Regulation going into effect in May of this year is a kind of sea change in data privacy regulations that apply to any companies doing, or not only companies, but any entities doing, having operations in Europe. And it's not just Europe, but in many other jurisdictions, and data localization requirements. And as these requirements appear and they diverge in various jurisdictions and business operations occur in all those jurisdictions, you can imagine the enormous complexity that generates enormous billable hours. So.
Well, we only have about 3 or 4 minutes, but I will take a couple short questions from the center here, maybe starting with Wes in the back, and then we'll come down to the front.
So if we accept the U.S.'s position on trying to be as limited in restricting free speech on the internet as possible, do we also have to address the reality that the way that free speech works on the internet also poses more significant risk? Things like swatting and doxing and indirect, where they don't fit into the traditional shouting fire or direct incitement of violence. Clearly the internet and what's on the internet has changed the risk to people. If we're not going to allow an international regulatory structure that tries to protect based off of restricting speech, do we have to do something more about the punishment and the deterrent side?
And then 2 down in front here, I think, again, as quickly as possible.
assuming the use of force has been authorized in some way, whether Article 51 or Security Council resolution or whatever it is, to what extent are these cyber tools that we've been discussing about kind of in the defensive posture a permissible offensive tool, the same as a missile or a physical invasion or something else? How does it relate to rules of proportionality, attribution, and things of that nature? Is it something that we consider now a legitimate tool that we can go in and use, or what's the legal framework around it?
And then last, Kiara, did you have a last one?
Thank you. Very briefly also, thank you for the very interesting presentations. My first question is, some of you had said that both within the Budapest Convention and within the United Nations, there were some sort of blocks negotiating so that the US had one position and others were more resistant. And I was wondering if you can elaborate a little bit on that and what are the negotiating, what is the lay of the land in terms of what are the issues, but also the negotiating countries and what their issues are of concern. And the other, very briefly also, but it's a little general, it seems to me that this is a field in where non-state actors can play a very important role in shaping the norms and the rules as they develop. And I wonder, what is the space and how can companies or individuals, how are they included in the negotiation, if at all? Thank you.
Yeah, please.
Okay. So to answer both the first and the last question, one thing that I didn't have a lot of time to talk about is the question of terms of service for companies, or community standards, as some companies talk about them. So most companies have in their terms of service, at least the large companies, prohibitions on hate speech. Of course, I know that they get a lot of criticism for how they define it, but it's a work in process. And terrorist content. And again, it's very difficult to define what terrorist content is, but most of the major companies have this. And part of what the GIF-CT is doing actually is to work with smaller companies to bring their terms of service kind of into alignment so that there is more consistency in what would be there, and also to remind them, hey, you might want to have terms of service so that you can boot people off if they're doing crazy things on your platform. And so that, I think, is a direction where a lot of this is going, and that's really good. And so international human rights law governs the behavior of a state towards individuals in its territory, largely speaking. And so it doesn't reach companies, right? So many companies they can boot people off if they want to. They don't have any either First Amendment or free expression obligations not to do that. They have other restrictions, and of course, many of the companies have sort of an ethos towards wanting to promote free speech and promote free expression, but they also, want to promote a safe space for people to communicate with each other. So for that reason, I think, the answer to the last question is also an answer to the first question, and that we really see companies taking a lot of leadership here. In a lot of ways, I think that is good. And that also means that, right, we're giving companies a lot of say over what we can, talk about online. And so I think that there is a lot of discussion. Like I said, the UN Tech v Terror is a UN group that's working with companies, so there's a lot of state industry engagement. But I'll just say there is a huge amount of industry and government dialogue on this topic. It's incredible. So the other place you can make oodles of money is to go work for a social media company, because they have a lot of attorneys working on this.
Beth, do you want to take the Budapest Convention question?
Sure. So I more was referring, unlike the GGE context, I was more referring to sort of the Budapest Convention parties versus the non-parties as the two blocks. Sorry? The Budapest Convention parties and the non-parties as the two blocks who have competing views of the internet. And when it comes to sort of the non-Budapest members are the ones who are leading the push for a UN instrument to supplement or replace the Budapest Convention. But within Budapest, you do see divisions. There are probably, as you might expect, there's differences between more developed nations, particularly in terms of the internet, and less developed nations regarding sort of how particularized a lot of the tools have to be and how much they're willing to adopt rules that require a lot of resources. So there's a 24/7 network created under the Budapest Convention where you have to have somebody available to provide international cooperation on a 24/7 basis. In the US government, that's sort of no big deal. There are many countries for whom that is a much bigger deal, particularly because that person has to be able to operate in English in a realistic fashion. You also see big splits. The parties of the convention at the moment are about half EU countries and half non-EU countries. So you see very large splits in terms of just the norms that govern things as they are now between the EU, who has a lot of these things already in place with regards to EU member countries, and they sort of have a system, and they're like, why can't you just join our system? And all the other countries who are very diverse even among themselves, but sort of are united by well, we're not under the European Convention of Human Rights, and it's not so easy for us to do direct judge-to-judge communication because there's no overarching set of rules that would apply. So that's one thing. You also see a bit of a split between common law countries and civil law countries regarding sort of how they expect laws to be structured in the first place. So it's interesting in part because there's many, many different blocks and people we think of as very like-minded in many, many contexts. For example, Germany actually has basically the opposite, in many ways, legal regime governing cyber behavior in the way that the U.S. massively encourages our U.S. internet service providers to cooperate voluntarily in emergency situations. They're completely prohibited from doing so in Germany. So there's very big differences you wouldn't expect to be there.
Jonathan, do you want to take this question from the front?
Sure, and in the interest of time, I'm just going to point you to a document that's publicly available, which is the U.S. submission to the 2014 to 2015 GGE. It's in the State Department's Digest of U.S. Practice and International Law. We address the very questions that you raise, how might states be able to respond to a cyber act that amounts to a use of force or an armed attack? What is the legal framework that governs? We get into the jus ad bellum, the jus in bello. So take a look there. I think you'll find a lot more detail than I'll be able to cover right now.
Well, with apologies to those on the internet whose questions we didn't get to, including the Bitcoin question that probably relates to that rules of money issue, I think we need to draw it to a close. I'd like to say a couple things. First, when I joined the State Department Office of the Legal Advisor myself back in 1987, there was no internet, there were no cyber issues, no email. Life seemed very simple back then, and a lot has changed by today. But what has not changed is really the stellar quality of the lawyers in the Office of the Legal Advisor. I think the United States is extremely lucky to have you in your service on these issues. You've done terrific presentations today, and I think it really shows how that office shines among within the government. Let me also say that we have to express thanks to the sponsors of the event, the ABA section of International Law, Sophie Wilma, Renee Goplik. We're extremely lucky to have your assistance. We've got Mark Agras and Wes Rist from the American Society of International Law, and Mary Beth is here somewhere as well. And Sarah Freuden and Selena Davis, who did a lot to help organize as well. I'm sure I'm missing others. But I specifically need to call out Ron Bettauer, who's the glue that has kept this thing going. He started it, he kept it going. He kind of transcends all three of those groups, so I'm not quite sure where I put him. But we're very lucky to have your support for this project. With that, please join me in a round of applause for our presenters and for those that organized this event.
Newstead.